As the witness is entering, just so we're clear, I had prepared to present the other witness now that we had the information which was necessary as a foundation for Mr. White. That's where I got that information. So I understand the state's normal ability to cross-examine, but my understanding, just so the court is clear, that we were setting that as a foundation for the actual witness to testify. So.
Well, we had a witness on the stand
Sure.
in the middle of the hearing who decided to continue it, so
Yes,
we're going to go ahead and go forward with Mr. White. Yes,
I believe that he's being gathered at this point.
Your testimony is pursuant to the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do, so help me God.
Thank you.
Morning, sir. State your name, please.
My name is Wesley White.
And you recall being here last week testifying concerning a matter regarding sanctions against the state attorney's office?
Yes, sir, I do.
And at that point, you had identified a client of yours who was or is an employee with the state attorney's office, correct?
That's correct.
And have you brought him here today for testimony?
He's waiting outside.
Thank you. Mr. President.
May it please the board? Mr. White, the person you talked about, Mr. Krybos, he is a friend of yours, is that correct?
Yes.
Okay, and how long has he been a friend of yours, sir?
We object, Your Honor, on grounds of relevance.
Your Honor, this is to show bias.
As to, I would ask, rather than general bias, that it be specific to something the court should consider as to whether or not this witness, who is limited just to identify communications he had with a client.
in my courtroom, this is for all of you. I don't want to speak to objections, particularly during trial. So your objection is relevance, he said bias.
Let me correct that answer. We're not social friends, but I consider us friends. Sort of like you, Mr. Del Ronda.
You were friends, you are and were friends with Mr. Krybos, is that correct?
That's correct.
All right.
But not social friends.
Okay, so you have never had him over to your house?
No, never.
And he's
well,
not-
actually, he was over and saw my daughter and helped her with a computer problem at one time.
Okay. My point is, even though he worked and is currently still working at the state attorney's office, you knew him also on a social basis, too?
No, that's not correct.
You did not?
I've never had dinner with him. I've never had lunch with him. I've never shared a beer with him. And to me, that constitutes a social basis.
He also lives in Nassau County where you live, does he not?
That's correct.
Okay. And he has gone to great lengths to help you with your computer?
No,
State
sir.
attorney's office? Never?
I don't know that he's gone to great lengths. I know that he has worked on my computer and every computer in the office.
Okay. Let's if we could, talk about your employment with the state attorney's office. You were employed at the state attorney's office for almost
Again,
a
Your
decade.
Honor, if I might object on grounds of relevance.
This is to show bias, Your Honor, as to his reason for coming forward. You were employed with the state attorney's office, I think, almost exactly 4 years. Is that correct?
From January 2009 through December 2012.
Okay. And you had no prior prosecutorial experience. Is that correct?
That's correct.
Okay. You really did not have any real trial experience either, did you?
Well, I would disagree with that.
Your Honor, objection. I don't want to just keep doing it, but on grounds of relevance as to his prior trial experience.
The relevance is, I'm going to hopefully establish, Your Honor, if I may, in terms of his bias and his reasons for coming forward and for getting Mr. Krybos to also come forward. Your Honor, these witnesses were actually never listed as witnesses. They were just brought in court without no prior knowledge. I haven't had an opportunity to depose this witness regarding.
We don't do depositions.
I understand, but I am trying to establish his bias, I guess, to answer the court's. Thank you, Your Honor. You came to the state attorney's office to manage the Nassau County office, is that correct?
That's correct.
Okay. And you really had no prior criminal trial experience, correct?
No, that's not correct.
How many prior trials had you done prior to coming to the state attorney's office?
How many criminal trials?
Yes, sir.
2.
2. Okay.
I believe 2. May have been more.
All right. And how long have you been an attorney?
33 years.
Okay. And you helped out Ms. Corey in her campaign, which she ran in 2007, 2008. Is that correct?
I did.
Okay. And after you took over the state attorney's office, Nassau branch, there was a change of division chiefs in terms of actually handling the cases day to day. Is that correct?
Yes.
Okay. Isn't it true that there were issues while you ran the Nassau State Attorney's Office involving yourself?
I don't understand your question.
I'll be glad to rephrase it, sir, so you can understand it. Wasn't there problems with employees that you managed?
In my opinion, no.
Okay. Did you not make inappropriate comments to certain employees of the office and result in a lawsuit against the office?
Let me object, Your Honor. Relevance and though it's cross, he is testifying himself concerning matters not before the court.
The answer is no. Actually, a lawsuit was brought against the state attorney's office as a result of a wrongful termination alleged to have occurred by Cheryl Peak, Angela Corey, and Dan McCarthy. I was not named as a defendant in that lawsuit.
You're well aware of the person we speak of, right? The
I
person?
believe so.
And didn't she allege that you made inappropriate things to her? Or
She made that allegation, yes, sir.
Okay. You also, is it not true, had issues with the law enforcement officials, at least one of them there in Nassau County?
Again, you're speaking very expansively.
Sheriff Seagraves.
Yes, I had problems with Sheriff Seagraves.
Now, isn't it true that while you were employed also there at the state attorney's office in Nassau, running that office, that Mr. Guy and I had to go up there and handle one of the biggest murder cases there, the Ratley case?
I think the two are unrelated. You had that case before I came to work at the state attorney's office. In my understanding, it was assigned to you before I ever came to the state attorney's office.
Okay.
I would have gladly tried the case.
You felt you were qualified to handle the case?
I think so. Okay. I secured the first degree murder conviction of Ms. Corey's tenure in office, and that was a case that had been mistried by Doc Burgess, a former county court judge and former prosecutor before me.
Did you do that trial?
I did that trial with Bobby Lippelman, yes, sir.
Okay, and how much of the trial did you actually do?
I gave the opening, I gave the closing, and I did most of the cross.
Okay, so that would be your first murder case?
That was my first murder case.
Okay. All right, let's not dwell on the matters. My point is, at some point, your performance in the office was an issue, was it not?
Not to my understanding.
Okay. Wasn't your performance lacking? Specifically, in November of 2012, weren't you brought to the office, and did I, not myself, Ms. Corey and Ms. Peak, have a conversation with you regarding the performance or lack thereof of the office that you were managing?
That's an absolute misstatement of fact.
Did you not ask Ms. Corey specifically, in my presence and Ms. Peak's presence, that if she could give you another 6 months to get that in order in terms of the problems you were having in Nassau County?
That's not correct.
What, you didn't say anything about another 6 months?
I did say 6 months, but you'll recall that we had a sheriff that we had a problematic relationship with, and I'm talking about the entire state attorney's office. We had a new sheriff, and I felt that this new sheriff would bring more cases, and the issue was, according to you, sir, that we weren't trying enough cases or we didn't have enough caseload in Nassau County. That was the issue.
The bottom line, without belaboring it to this court as to relevance in this case, isn't it true that you were told that you were being demoted, that you were going to get a cut in pay, and that you were going to be transferred to the Special Prosecution Unit and to report to a director, Mr. Manti? That was the option you were given, isn't that true?
No, sir, it is not.
You were never told that?
Sir, I wasn't told what you have just stated in your question.
You were not told that your salary was going to be decreased?
I was told that, yes, sir.
Okay. So let's break it down, because
Please.
you were told that your salary was going to be decreased, correct?
That's correct.
Okay. And you were also told that you were given an option that you no longer were going to be in charge of the Nassau County office. Is that not true?
That's correct.
Okay. And you were told that your option was to come to the state attorney's office in Duval County and to work economic crime cases or white-collar crime cases.
That's my understanding.
Okay. And you were to report to a director, Mr. Manti.
I wasn't told that, sir.
Okay. So that's the part that you forgot.
Well, that's at least one of them.
Okay. And so your position of authority over Nassau County was no longer going to be in effect, in other words?
My understanding and what I was told was because of budgetary concerns, the director's position in Nassau County was being terminated.
Because of budgetary concerns?
Did you not hear me, sir? Yes, budgetary concerns.
So it wasn't because of your performance?
No, sir.
It wasn't due to the fact that you were only carrying a caseload of 2 while other directors in the office were carrying caseloads of 15, 20 cases?
As far as I know, no, sir. And I don't agree with those figures either.
You don't agree with those figures?
No, sir, I do not.
Okay. You remember me sending you an email regarding the performance in Nassau County?
No, sir.
You never received a...
I don't recall receiving any email from you complaining about or bringing up my performance as an issue.
Okay. Let me see if I can refresh your memory, sir.
Pardon me?
Let me see if I can refresh your memory. Back on November 15th, let me...
If there's an opportunity, yeah, I'd like to see it if I might.
I'll be glad to.
Thank you.
You're welcome. If I may approach you with your You recall that I sent you an email on November 15, 2012?
I don't recall receiving that email, sir.
You don't recall the email stating, in fact, Wes, please call me on a text when you have a moment regarding the case count. Your case count was Wes White, 2 cases you were carrying?
I don't recall receiving that email, sir.
Well, do you recall how many cases you had in Nassau County that you were actually handling yourself?
I was involved with all my attorneys on all their cases, tried most of the cases with them, and was doing a significant amount of work in those cases.
Don Carter, who was mentioned in that email, she was in charge of what in the office there, sir?
She was a unit supervisor.
And isn't it true that on this email it states Laura Coggin had a caseload of 95, Beverly Collins 79, John Kalinowski 2, Donna Thurston 27, and you had 2?
That's what that document says. I don't recall receiving that document.
You dispute that you only were having actually 2 cases?
Yes, I do.
Can you name the cases that you yourself were handling yourself?
Not at this time, no.
Okay.
Do you want to give that to the clerk and then mark it as an
Yeah, sure.
identification statement for this meeting?
Now, you do recall meeting with me and Ms. Peak and Ms. Corey, correct?
I do.
Okay. Thank you. I'm sorry. Did you get to see it again?
Only if you're considering attempting to admit it, but it's just being marked for,
Identification.
yes, thank you.
And in that meeting, we had discussions about your performance, did we not?
No, sir, not my recollection.
Okay. So this was just a meeting to say, Wes, you're doing a great job in Nassau County, and we wish you stay with us for another 4 years?
Well, I was invited to stay another 4 years. It included many subjects, including the Trayvon Martin case.
You were asked to take over the Trayvon Martin case?
No, sir, I was not. I was castigated by Ms. Corey for my hand or my involvement, that she believed, in bringing that case to her circuit.
Well, since you mentioned the Trayvon Martin case, George Zimmerman case, isn't it true that you wanted to handle the Trayvon Martin, this George Zimmerman case because you wanted the publicity?
I wanted to handle every single case that came to my office.
Okay. Well, let's see if we can keep on track, sir. You ended up, after the meeting with Ms. Corey and myself and Ms. Peak, where you were given an opportunity to be demoted in terms of salary and being sent to Duval County, you declined that. Is that not true?
Not immediately, no, sir.
How long after did you decline that, sir?
Well, I think you received an email from me a day or two later saying that I declined and did not wish to be reappointed to another term with Ms. Corey.
In fact, you're December the 5th. Does that sound about right?
I don't recall the exact date.
Where you specifically state, Dear Angela, a formal and appropriate letter will
Let me
be
object, Your Honor, that's just improper use of a document.
If you'll show it to
I'll
council
be
first,
glad.
and then show it to council first, and then show it to.
Thanks. My concern is more, It is an improper use of a document in examination of a witness, but I've seen it. But
I wanted to make sure you saw it before
Thank
you
you.
chose to do this, before we proceed further.
certainly, and normally, Your Honor, my objection is that if in fact he's going to testify or have him testify from it, rather, I'm trying not to speak.
It's not gonna be read into evidence at this time.
Generally speaking, he has to not have a current memory of what happened before a document is used to refresh his recollection.
You can have him identify it.
Okay,
That's what we need to see.
thank you.
Thank you.
Yes, sir.
Okay. Do you recall that now, sir?
Yes, I do.
Okay. And do you recall that document, and we'll label, if we could, Your Honor, State's Exhibit B for identification?
We can mark the state's exhibit B for identification.
Do you recall the bottom part of that document as the email that you sent to Ms. Corey?
Well, I recall my email, which says, Dear Angela, and I recall it in its entirety. Yes, sir.
Yes, sir. And do you recall the top part of that document, my response to you? And if I may, Mr. West.
Take a look. Yes, the portion which said Ms. Corey would like to present a plaque to you at our annual office awards luncheon. Yes, sir, I do recall that.
Well, if you're going to read part of it, let's go ahead and read the whole thing, so there's a complete record of the response. I guess I am, since he's read part of it, Your Honor.
Is there any objections?
There is improper foundation at this point.
He's identified the exhibit as something that he wrote and received, so it will come into evidence for the purpose of this hearing as state's exhibit number 1.
Now that's in evidence, would there be a copy available possibly? Or-
Sure.
Great, thank you.
For you. If we could, sir, do it chronologically, State's Exhibit number 1, if you could first read your email to Ms. Corey.
Dear Angela, a formal and appropriate letter will be forthcoming, but I didn't want to leave you or Rich in a lurch as to Friday. With respect to the Morganty meeting, you may wish to have another ASA or outside counsel appear in my stead. I no longer seek or will accept reappointment to the office of the state attorney for your second term. Given the few days left of my service, realistically, I would not be able to effectively pursue any matters with the city of Jacksonville. I will work diligently to clear pending matters on my desk, and as always, I'm grateful for having had the opportunity to serve the fine people of Nassau County.
And do you recall my response to you, sir? That's on the top of that document.
Yes, sir, I do. Shall I read that as well?
Please.
Wes, inasmuch as Ms. Corey is out for a funeral, I am responding on her behalf to your email below. She accepts your resignation and looks forward to having a continuing professional working relationship with you. For planning purposes, we need to announce your departure from the state attorney's office and immediately begin planning for staffing needs created by your intention to move in a new direction in your career. Please forward your supplemental resignation letter at your earliest opportunity so that we can continue to move forward and make a seamless transition. I will get with you tomorrow to get the details about coverage needed in Nassau County between now and January 8, 2013. Ms. Corey would like to present a plaque to you at our annual Office Awards Luncheon on December 19th, and we hope that you will be amenable to that. On behalf of the boss and the rest of us, we appreciate your efforts in Nassau over the past 4 years.
Do you recall those as being two accurate emails? Is that correct?
I have no reason to believe that they're not accurate.
You, in fact, did not tender a formal resignation letter to Ms. Corey, did you?
I sent an email later on in the week.
You sent an email not to Ms. Corey, but to the whole office, did you not?
I did, but I also copied Ms. Corey, I believe.
Obviously, she works at the office. She's the boss, so she would be included in that.
Right.
Not agree? And do you recall the nature or the tone of that email?
Well, I imagine it was somber. A good friend of mine and our county court judge had passed the day before, and that day I sent off a notice to the entire office that Judge Burgess had died, and I also sent a notice that I would be leaving the office of the state attorney.
Do you recall anything else in the nature of that email that you sent?
I think I thanked law enforcement, and I thanked the people, the very good people that I've worked with, and I can't recall beyond that.
Did you make anything, negative comments regarding Ms. Corey or her office?
I don't recall. Oh, yes. Yes, I did. It wasn't negative. It was a statement of fact that when she ran for office, she had promised that, and this was a campaign promise made in Clay and Duval and Clay and Nassau counties, that she would have a local attorney managing that office. And I reminded her of that, and I told her that people would remember her more for the promises that she kept than her wins and losses.
And isn't it true, sir, that what we did is actually sent two attorneys that actually had, I want to say at least, what, 30 years or 60 years combined experience more than you did in criminal matters?
They weren't from Nassau County, and they didn't even know which way the roads ran.
Did they have more trial and criminal law experience?
Yes, sir, they did.
Both of them did?
Yes,
That's
sir.
not true. That is the division chief, Ms. Donna Thurston, and the senior division chief, Mr. Steve Siegel.
That's correct.
And you have no issue regarding their qualifications, do you not, sir?
I don't know their qualifications other than that they've been there at the state attorney's office for a long period of time. But again, I know that they don't know which way the streets run in Nassau County. They don't know the difference between a pulp mill and a pogey plant.
Sir, you also, I believe, sent me some congratulatory emails, did you not, sir?
Pardon me?
You sent me some congratulatory or congratulations emails?
I hope so.
Okay. And also Mr. Guy, in terms of when he was appointed senior director?
I hope so, yes.
All right. So your issue in this case is you felt you had to come forward because you had some information, is that it?
I'm an officer of the court, as you are, sir, and if I believe or if I come to understand that misconduct may have occurred, that you or any attorney may have misrepresented something to the court or had otherwise confounded the process that we live by, that I have an obligation to look into it, and that's what I did.
Okay. And this came to your attention through Mr. Krybos?
That's correct.
Okay. And he came to you as a friend, correct?
He came to me seeking legal advice as an attorney.
So he hired you as an attorney?
That's correct.
Okay. And the payment on that is how much, sir? How much?
I haven't charged him yet.
Okay. And when was that exactly that he came to you seeking your advice as an attorney?
Approximately 6 weeks ago.
And when was that exactly?
I don't recall exactly.
I think last time, and I may be incorrect, did you say 5 weeks ago or you say now 6 weeks? And I may have that.
Well, if I said 5 weeks ago, it'd be a week later, so now it would be
So it
6
was
weeks.
6 weeks.
So approximately.
I want to make sure it's accurate. You're thinking sometime when?
I don't have a precise date, sir.
Okay. Did you log him in as a client anywhere in your files or anything?
No, sir, I did not.
You did not open a file regarding him?
I maintain my files on my computer with regard to notes that I take and subjects that I need to be looking into.
Okay. And so he came to you out of the blue, or did he call you ahead of time?
I don't recall.
Okay. And you met with him where, sir?
I don't recall that either. It might have been Chili's. It might have been.
Was it a restaurant of some type?
I don't recall.
Well, did you go to the state attorney's office and meet with him there?
No, sir, I did not.
Okay. Did you meet him at your office?
I don't have an office at present.
Okay. Did you meet him at your house?
I don't recall. I don't believe so, but I don't recall.
Did you travel to his house in Nassau County and meet him there?
I've never been to his home.
Okay. Was he on the clock? Was he working as an employee of the state attorney's office when he met you, sir?
I don't recall the specific time.
Do you recall what time you met him? Was it at daytime or was it at nighttime or was it, at midnight?
It wasn't midnight, sir, but I don't recall a specific time that I met him.
Okay. Is there a reason why you did not notate when you met with him?
No.
Okay. You said you made a note of it in your computer?
That's how I would typically deal with any client matter. I would make notes in the computer and also a list of things that I needed to do.
Yes, sir. And do you have that in front of you, sir?
Pardon me?
Did you bring that with you?
No, sir, I did not.
You don't have any type of iPad or anything?
No, sir, I do not.
You don't have any kind of phone or anything where you can look that up?
I have a phone, but I don't have the capability to look it up here.
Okay. So you met with him and he told you he was concerned about something, is that correct?
That's correct.
Okay. And what exactly did Mr. Krybos tell you?
Your Honor, he's well capable of making an attorney-client objection. I just want to make sure that it's clear that I'm not waiving something, because if in fact
It's
these,
not your attorney-client privilege.
that's why I'm doing it hesitatingly,
What is
but
your objection?
I'm concerned that it is not proper.
Concern is not an objection.
Okay, then I'm going to sit down.
He came and told you something, correct?
Well, with respect to this matter, he was concerned about whether he had any kind of criminal exposure as a result of actions or possible actions by you, sir.
Okay. And so he specifically told you that he was concerned about a criminal matter.
I've given you an accurate representation of
Those
what
were
he
his
said.
words, not yours, is what I'm getting at.
Pardon me?
Those are his words exactly, not yours.
No, they weren't his words exactly.
Well, what were his words exactly?
I don't recall his words exactly.
Did you make any notation anywhere of what he said?
Not that I recall here.
Not that you recall here, or not that you recall at the time?
Not that I recall now. At this point in time, I don't recall if I made notes with respect to the specific words that he used.
Okay. Well, at some point, did you meet with Mr. Romero, Mr. West, or somebody to let them know about this?
I never met with Mr. Romero.
Did you meet with anybody in that office?
No, I never did.
How did Mr. Romero become aware that you knew something?
I called his office.
Okay, so you called his office.
Yes, sir.
And when did you do that, sir?
I asked him if he had received photographs and some deleted text messages, and I gave him an understanding of what those photographs were.
Okay. And when did you call Mr. Romero's office?
Shortly after I was retained by Mr. Krybos.
And when would that have been, sir?
Again, about 6 weeks ago.
Okay. And how did you just pull up Mr. Romero's number on the internet or something? How did you know his phone number?
I don't recall.
You had prior meetings with Mr. Romero about this case?
I've never had any meetings with Mr. Romero about this case.
Okay, and let me make sure, I'm not trying to confuse you, but I'm just trying to get to the heart of the matter. When I say Mr. Romero, anybody in his firm, secretary, a paralegal, an intern, Mr. West, anybody else? I'm just trying to get this.
I've never met anyone in his firm before my appearance in court last week and seeing these folks here today.
Okay. And had you spoken to anybody in that firm on the phone?
I've spoken with Mr. Romero.
Okay, and you don't recall when that
And
was?
Mr. West, I believe, was present as well.
So this was like a conference call?
Well, a conference call and that more than 2 people were involved? Yes.
My question is, was Mr. West in his office, or did you arrange for Mr. West and Mr. Romero to be together when you spoke to them?
I didn't arrange for anything, and I don't know where he was.
So you happened to just call Mr. Romero's office and Mr. West was there and you spoke to both of them at the same time as your
I
testimony?
don't recall exactly how the transaction occurred.
My question is, did you call him ahead of time and say, listen, I need to talk to you about something, and Mr. Romero said, hold on, I need to get Mr. West involved? Or is it just a coincidence that Mr. West happened to be there at the time you called?
Well, I think there was more than one conversation with their office.
Okay.
And I think the initial conversation was just with Mr. Romero. Whether Mr. West was there or not, I don't know.
All right, well, what I'd like to do is have a breakdown of the initial conversation you had with Mr. Romero. You told him what, sir?
I told him that I understood that there were 3 photographs and deleted text messages that he may have not received, and I wanted to find out whether he had received them or not.
Okay. And did you identify the 3 photographs?
As best I could. My description was very vague. It was an African-American's hand holding a gun, drugs, an underage female, and deleted text messages involving either the purchase or sale of a firearm.
Regarding the what? I apologize.
Purchase and sale of a firearm.
Okay. And you told that to Mr. Romero?
That's correct.
Okay, and then the subsequent conversation was what? You mentioned you had 2 conversations at least.
That they did not receive that information from the state.
Okay, and you told them that they had not received it?
No, they told me they had not received it from
So
the
you
state.
first inquired as to whether they received it or not?
That's correct.
Okay. Why did you feel a need to call Mr. Romero to inquire whether they had received that or not?
Because I'm an officer of the court, and I believe that it's incumbent upon me to find out whether you had provided certain information, which I think is your obligation under the reciprocal discovery requirements of the Florida Rules of Criminal Procedure.
How did you know that it had not been given?
I don't know whether it had been or had not been. All I know is Mr. Romero said that it had not been.
Okay.
I have no independent knowledge whether it had been provided or not.
You have not examined the bin file or the dump file from the victim's cell phone?
I have not looked at anything. I've not received the actual photographs, the deleted text messages, or any material at any time.
So you have no independent knowledge whether that was turned over or not? You were just inquiring whether it had been?
That's correct.
Is that fair?
That's correct.
Okay. And did you ask him about anything else, whether anything else had been turned over?
Did I ask about anything else? No, sir, I did not.
So you only focus on those 3 items, right?
Those are the only things I was aware of. 3 photographs and the deleted text messages. And I believe the photographs were deleted photographs as well. But I'm not certain.
I don't understand what you said.
I think they were recovered photographs, like recovered deleted text messages, but I'm not certain. The text messages, I believe they were deleted, but the photographs, I don't know.
Okay. And what did, after the second conversation, what did Mr. Romero or Mr. West or anybody else in that firm tell you?
That they had not received it.
Did they tell you anything else?
I think that was, I can't recall anything else.
Okay. And then you just need to appear last time we were in court on April 30th, or whatever day we were?
They subpoenaed me.
Okay. Okay. So you
They did ask me the identity of my client, and I refused to give it.
Okay. You already had disclosed what your client told you, right?
I disclosed that that information was out there. Yes, sir.
Okay. And so I'm assuming you had some kind of agreement with, now we know the client is Mr. Krydboss, that you could disclose that, correct?
Yes.
I mean, he had agreed that there would be no attorney-client privilege.
As to that limited subject, when I explained my obligations as an officer of the court, he agreed.
Okay. And it was your understanding that these items you suspected had not been turned over to the defense, is that correct?
I had no suspicion whether they had been or not. I just felt I was obligated to find out whether they had been or not.
Okay, so the bottom line is you don't know whether they were or not.
I have no idea, sir.
Okay, but you felt the need to inform Mr.
Inquire.
Okay. And then you just showed up in court, right? You were subpoenaed.
I was subpoenaed, sir. Yes, sir.
Okay. And when did you receive that subpoena?
I don't recall.
Was it like the day before, a week
It was
before?
prior to my appearance. I don't recall when it was.
Okay. And how were you served?
By email.
Okay. You never felt the need to inform the state or anybody else about that?
I assumed that counsel would do that, or you would find out through looking through the court file. But
So
no,
you-
I did not.
You assumed that defense counsel would inform the state that you were going to be listed as a witness, or?
I just assumed that it would be listed somewhere.
Okay, would you be surprised that you were never listed?
I don't know that if I was listed or not. All I can do is take your representation that I wasn't listed or that you weren't informed.
Okay. Well, did you tell Mr. O'Mara, hey, listen, you need to let the state know, maybe I'm wrong, maybe that stuff was turned over?
That's a question that has multiple parts to it. And if you want to break it
You're a
apart-
lawyer, I'm trying to make it, I'll break it down for you if you want.
Please.
Okay. My question is, when you inquired to Mr. O'Mara, and did you say, listen, are you going to let the state know, maybe I'm wrong, maybe my client's wrong, maybe that stuff was turned over?
No, what I told Mr. O'Mara is I had no independent knowledge whether or not these documents had been provided, and it was just a question to find out whether they had been or not.
Now, in your discussions with Mr. Krydboss, did you also discuss with him his tenure at the office at the time, whether there was suspicions of something he had been involved in or not been involved in?
I don't recall any such discussions.
You did not have any discussions?
Sir, I don't recall any such discussions.
So that means you did not have those discussions with
That
him?
means I don't recall them, and it means also if there are discussions that are outside the parameters of the issue that are here today, I will assert the attorney-client privilege.
I understand. My question is, don't you think those are relevant as to establish bias on the part of Mr. Krydboss as to why he might come forward and make such an allegation?
I wasn't concerned about his bias or not. I was concerned about whether or not you had fulfilled your obligations to this court.
Well, you've been a lawyer for how long, Mr. West?
You've asked
Mr.
that
White, I
question before.
apologize.
It's 33 years, sir.
Wouldn't you, when somebody comes forward, wouldn't you automatically say, okay, hold on, what's your reason for coming forward? You've been working for the state attorney's office for so long, wouldn't you inquire as to what his motivation or bias would be?
No.
You didn't have any such discussion with Mr. Kreidboss at all?
No.
Okay. So now you do have a recollection, and you did not have such a discussion with him?
I don't recall any such conversation.
Okay.
But again, it would be covered by attorney-client privilege if I had. He may have a better recollection than I have.
I'm just trying to get your take on it of what, because he's testifying, so
Good.
I can call him, I guess, I call you after. You don't have an independent recollection at this time?
I don't.
Okay. And before you left the office, or at some point, did Mr. Kreidboss, was he involved in doing something with your computers at all? Do you remember?
My understanding is he picked up my computers, and it's my understanding that he picked up my computers, or the IT department picked up my computers, and they'd be recycled to somebody else.
You know why they were wiped clean?
I assume that was in preparation for the next user.
Okay. So,
And I don't know, in fact, that they were wiped clean.
okay. And also, by the way, have you been blogging about this case at all?
No, I have not.
You've never used the blog Little Rio?
No.
What have you blogged on this case?
My blog is Jesse Jacksonville, and it specifies my name, Wes White.
Okay, so you don't do an anonymous blog?
I don't
on this
do any
case.
anonymous blogging, sir.
Were you aware of a Little Rio being
I
blogged?
saw one in an article today that, well, came out last night. I have no idea who it is.
And in that article, you were quoted, correct?
Pardon me?
In that article, you were quoted, were you not?
Yes, I was.
Okay. You've taken this as an opportunity to, because you want to run against Ms. Corey in 4 years, correct? Or in 3 years?
That's nonsense.
So you have no intention of running for state attorney?
I have not made up my mind in that regard, but I'm here today because of my obligations to this court as an officer of the court.
At some point, you felt you should have been state attorney in West Palm Beach, isn't that true?
I applied for a vacancy of 8 to 10 months, I believe it was, for a position in Palm Beach County that was open.
And you were turned down by the governor, isn't that true?
I was not selected by the governor, that's correct.
Okay. Now, in your discussions with Mr. Kreidboss, did he tell you about his position having changed in the office in terms of his?
I'm sorry, say that again.
I'm sorry, I'll be glad to rephrase it. In your discussions with Mr. Kreidboss, when he came to you to report this, did you have discussions with him about his tenure in the office, and how it had changed in some ways?
I don't recall any such discussions. But again, that would be covered by attorney-client privilege. My focus was based on, again, my obligations. As soon as I heard this, my obligations and what I was required to do, my ethical constraints. And my ethical constraints were to go to this judge or through opposing counsel or find out whether you had complied with your requirements under the law. That's what my focus was. Otherwise, I would have been more than happy just to not be involved.
You didn't contact the judge, did you?
Pardon me?
You did not contact the judge, did you?
Did not do what to the judge?
You did not contact the judge.
I did not contact the
You
judge.
didn't contact the governor's office?
I did not contact the governor's
You
office.
didn't contact me and say, hey, is that true? What's going on?
No, I didn't contact you, sir.
You didn't contact Ms. Corey.
No, I did not.
And why is that?
That would be sort of like asking, well, let me put it this way, sir. If you've been engaged in misconduct, I think I would be the last person you would disclose that to. And if I could do it through a simple phone call with Mr. O'Mara, and if he could say, yes, we got those photographs, we wouldn't be here today. This wouldn't be an issue at all. But if I contacted you, I could not, if you had purposely misled this court, I don't expect that I would have gotten a straightforward answer from you. So that's why I didn't contact you.
It's not because of bias or anything,
It
correct?
has absolutely nothing to do with bias.
It's not because you were mad because basically you were told you were being demoted and you were no longer going to work at the state attorney's office other than in another position.
No.
Okay, so you didn't contact the judge who was presiding over this, who would determine what was going on,
No.
correct? But you did contact Mr. O'Mara.
That's correct.
Okay. And you felt that would be the appropriate way to do it,
I thought it was the quickest, simplest way to address an issue.
even though you had no independent knowledge that that actually had occurred.
That's correct.
Would it be fair to say that you're not a fan of the state attorney's office in the Fourth Judicial Circuit?
I think there are an extraordinary amount of very talented people there. Very good lawyers.
Because of the way you departed, or you were told that you had to depart, or the way you resign. I can't remember whether did you formally resign or not?
Well, I asked that I be kept on until the end of the term, but you interpreted that as being a resignation, so I think resignation is the operative word.
Okay, so you did resign officially.
Well, that's what you called it, so I'll accept it.
Okay. You weren't happy with that, correct?
I had mixed feelings about leaving the state attorney's office. I loved working for the people of the state of Florida, and particularly for the people of Nassau County. I loved being a minister of justice and making sure that this system that I've sworn my life to, my adult life to, is run according to the highest ethical standards available. I wouldn't trade it for anything. It was a wonderful opportunity to work for the state attorney's office. The circumstances of that opportunity changed, and so I was compelled to leave.
And that came about because you were questioned about the performance of your office.
No, sir, that's not correct.
All right, well, let me show you an email, and I'll show it first to Mr. O'Mara. I'll be glad to give you another copy.
Okay, thanks.
Let me make sure it's the same one, sorry. We could, Your Honor.
For identification.
State's exhibit, or for identification, State's exhibit C. Maybe you misunderstood my question, Mr. White. Maybe that will refresh your memory. On behalf of Ms. Corey, I apologize. Read it for a moment.
Okay, your question, sir?
But my question was, does that refresh your memory in terms of, on behalf of Ms. Corey, we were setting up meetings to review the performance of everybody in the office, specifically all the areas?
No, I don't recall that email.
You never got this email?
I'm not saying that. I'm saying it doesn't refresh my recollection. I don't recall it.
Okay. Your Honor, then I would like to introduce it into evidence.
Any objection?
No, thank you.
For identification will come into evidence for this hearing as State's exhibit number 2. What is the date of that email?
At the beginning, at the very top, it says November 30th, 2012. And Mr. White, at the bottom, it says November 29, 2012. I'll read it with you, so make sure I don't say anything correct. It says, Wes, are you available to meet with the boss and me next week? I was thinking Tuesday, but need to verify boss's schedule. Thanks, Bernie. And you recall a response on your part on November 29th at 5:43 p.m. certainly, and if an opportunity exists tomorrow, Friday, that would also work out well. Any subjects that I can prepare to address. And then I responded, Wes, I'm out of the office today, so let's leave it for Tuesday. I'll check and see when the boss is free that day. As you know, Ms. Corey's first 4 years has resulted in dramatic improvements. The media doesn't like to give us credit, but the public certainly is aware of what we've done. Nevertheless, we can always enhance our performance. We're in the process of reviewing the performance of all areas of the office and making adjustments to make this an even more efficient and better place to work. We are meeting with the heads of all departments. And then you responded on November 30th at 7:02 a.m. Excellent, thanks. You don't recall that at all?
No, sir, I do not.
Do you have problems remembering things? Or do you have a vivid recollection of things?
I remember a lot of things, sir. I remember those things that I believe I need to remember.
Are you
But after
disputing?
pardon me.
I apologize.
I was going to say, after 33 years, you learn to sort of box off things that need to be remembered and others that sort of you can let go.
Unpleasant things you kind of want to put to the side.
No, not necessarily unpleasant things, sir.
Okay.
I remember you. I remember Mr. Guy. I remember many fine people at the state attorney's office. But if you asked me many of their names, I couldn't tell you because it's simply something I don't remember.
So since you mentioned my name and Mr. Guy, and you also in that same sentence, I think, maybe it wasn't intended, you said fine. Am I considered a fine individual or not?
I think,
Now, I object, Your Honor, on grounds of relevance.
Okay. But you don't remember the series of emails?
I don't remember that email, sir. No, sorry.
All right. Now, if I may have a moment, Your Honor. Finally, sir, you mentioned that you went to Mr. O'Mara because you felt potentially something had happened, correct?
That's correct.
Okay, so in your opinion, that would have been misconduct if it had occurred, potentially.
Yes, potentially, yes.
Did you report that to the Florida Bar or anybody else?
No, I reported it to counsel, and I left it to him to deal with it as he thought fit to bring it in front of the judge.
So the bottom line is you didn't think it rose to that level?
Well, I didn't know. All I had was his representation of that he had not received it. I didn't have those files. I did not have the panoply of discovery that had occurred throughout this trial to check and see. Had I done that, and had I determined, I might have come to the court directly, but I didn't. So the quick way was to call Mr. O'Mara.
So you know, as a fellow lawyer, you have an obligation, if you're aware of misconduct by another lawyer, that you have an obligation to report it to the Florida Bar. Well,
I think what we're here today to do, sir, is to determine whether there was misconduct. And if the judge doesn't refer to the Florida Bar, well, then I guess, according to you, maybe I should.
Well, didn't you make a comment after the last hearing where you were here in court and you made a comment about myself, Bernie De La Rionda, that you were saddened by what I did?
Yes, I did.
Okay, well, do you want to take that back now since you're unsure of what exactly happened?
No, I think that quote was not exactly. The question was, the predicate was, if this happened, would you be surprised? And I said, I wouldn't be surprised, but I would be saddened.
Okay. Wouldn't you agree that assumptions, we shouldn't rely on them? We should rely on facts?
Well, you know what assume stands for, don't you?
What?
Make an ass out of you and me. So, yes, I generally agree with that.
Okay, thank you, sir.
Oh, yes, a couple of questions. Was that last exhibit put into evidence?
No, it's
May I retrieve them from the clerk?
Yeah.
I believe it was.
not. Oh, I'm sorry, it was. It's in evidence.
Good morning, sir.
Good morning.
So, tell us specifically, as Mr. De La Rionda asked you, why you felt it was necessary to inquire of someone, turned out to be me, regarding potential misconduct.
If a report was generated by the state attorney's office and it was preceded by another report from the Florida Department of Law Enforcement that was incorrect, and unless that correct report was provided, I think there's a misleading nature to that transaction, and also I think reciprocal discovery requires that that report be provided.
And you took the option of contacting me, correct?
That's correct.
And what did I tell you about whether or not we had received the documents that you were concerned about, whether or not we had received those from the state attorney's office?
You told me that you had not received them from the state attorney's office.
Did I evidence in that conversation other concerns to you regarding ongoing discovery issues that I had with the state attorney's office?
I don't recall.
Did I at that point then ask you who the person was who gave you that information?
Yes, you did.
I think you testified that you maintained that in confidence, correct?
That's correct. I refuse to give it to you.
Mr. De La Rionda has spent some time questioning you to suggest that you did this, that you called me and put these in motions because you have a bias against the state attorney's office. Do you recall those questions?
Yes, sir, I do.
And he spent some time talking about why you left the state attorney's office.
That's correct.
Did you leave the state attorney's office in such a way that you felt that you wanted to get back at them in some form or fashion?
No, not at all.
How long ago did you leave the state attorney's office?
December of 2012.
In the intervening 17 or 18 months, have you...
Excuse me, that would be seven.
Well, 7 or 8 months, I'm sorry. In the intervening 7 or 8 months, have you written any editorials or letters to the editors castigating the state attorney's office for their actions?
I have not.
Have you written any blogs attacking the state attorney's office?
I have not.
Have you written any letters to anyone attacking Miss Corey as being the state attorney's up there in the fourth?
I don't believe so.
Have you done anything to suggest that you are biased against the state attorney's office such that you would create a controversy that doesn't otherwise exist?
No, sir.
Mr. De La Rionda had you review what is now an Exhibit 1, which suggests to be your initial resignation, correct?
That's correct.
Have you had a chance to review it enough so I don't need to show it to you again?
I recall it, yes, sir.
Okay. Do you believe that there's anything within the context of that letter that suggests bias?
No, to the contrary, I express my gratitude to Ms. Corey for the opportunity to serve the people of Nassau County. And I'll express it to her again today.
The response from Mr. De La Rionda, again, you've had a chance to review it.
Yes.
Does that response from Mr. De La Rionda to your decision to not seek further employment with the state attorney's office, does that indicate any animosity towards you?
Well, I don't see it in there.
Any concern even with how you had performed your duties?
No.
Any issue whatsoever which may have suggested that there was animosity between you and Mr. De La Rionda?
No,
How
not that I
about
see.
you and anybody in the state attorney's office?
I didn't interpret it that way, no, sir.
He has made a concern and suggests that it's bias that you only had 2 cases that you're covering in Nassau County. Was that a concern within the office at the time you were employed there?
The concern that I recall was that we didn't have enough cases because the sheriff's office was not bringing enough cases to our office. And my response was, wait till the new sheriff starts in January, and I think you'll see things considerably pick up.
Is a lot of information flow back and forth in the state attorney's office by emails?
A lot is a subjective.
Okay.
We were generally encouraged not to put a whole lot of things in email.
Encouraged by whom?
By the management staff.
Did they give you any reason why you should not put information in emails?
I don't have a specific understanding of why, but it maybe perhaps has to do with the public records law, but I don't know.
Okay. Yet it seems there was information back and forth between you and Mr. De La Rionda concerning your performance and Nassau County's performance, correct?
Well, again, I don't think it related to my performance. It related to the overall office's performance. And that was not really performance. It was more of a factor of the number of cases that we had.
Have you had an opportunity to review the state attorney's office internal email files, to review all of the emails that might exist documenting information flow between you and Mr. De La Rionda?
I have not.
Okay. Do you have access to that?
I do not.
Okay. For those that do have access to that, are there any other emails out there that would suggest, besides these, any concerns for your performance that might suggest bias in the email system of the state attorney's office?
Honestly, I don't recall any.
In addition to the questions I asked you a moment ago, have you had even conversations with other people where you have attacked the credibility of the state attorney's office in any form or fashion which would suggest that you're biased against them such that you would make up this information that you presented to the court?
In no circumstances, with bias or without bias, would I make up any information presented to this court.
You had mentioned that you were contacted by your client and that he had a concern. What was his concern when he first contacted you?
His concern was whether he would face criminal exposure of some kind if the trial went forward and this material had not been provided to the defense.
And tell the court, if you would, of that conversation regarding his potential criminal exposure. What do you mean by that?
Well, he was very vague and really didn't understand that what his possible exposure might be, and it was hard for me to fashion a response because this was such a curious area and that it doesn't come up very often. And I think my response to him was possibly.
And when you told him that he might have criminal exposure, what was the act that he was concerned that either he had done or that he had not done, which would lead to potential criminal exposure?
Well, that he had discovered information and discovered the report from the FDLE was incorrect, and that information had not found its way to the defense.
And was his concern that he, having known or being aware of that information, might also have criminal exposure if it wasn't uncovered and forwarded?
I think that's a fair characterization.
And did you advise him again that he might have such exposure?
I think the word was potentially or possibly.
And did that potentiality impact on your decision to come forward with this information?
Actually, no. My decision to come forward was based on the fact that I'm an officer of the court.
When Mr. Krudbos, is that the correct
Krydbos.
Krydbos, sorry, advised you that he had this information, was it limited to those sort of high points of the photographs and the one text message that you referenced in your earlier testimony?
That was all that he made reference to me about. So I don't know if they're high points or low points or mid points or whatever, but they were the 3 points that, or 4 points, the 3 photographs and the text messages that he relayed to me.
And was his concern to you then that he wasn't certain that that information had been turned over?
That's correct.
Then you called me, correct?
That's correct.
Advised me of that. And what did I advise you about how I would look into addressing that issue?
Counsel, I don't recall you telling me that you're going to look into it. My recollection is that you told me that you had not received those files, those photographs, those deleted text messages from the state of Florida.
Did we have a discussion about filing a motion to uncover this information by filing a motion for specific discovery regarding all of the reports on Trayvon Martin's phone?
I don't recall.
In subsequent conversations between you and I, have I advised you that I filed such a motion that was heard before this court several weeks ago?
I don't know if you advised me or if I found it on your website and read about it there.
You have an opportunity to look at the hearing, evidencing what Mr. Del Rionda's response to the court's inquiry in that regard was?
I recall the one at the end of April, yes, sir.
And what did Mr. Del Rionda say to the court in response to her inquiry as to whether or not he had received any other reports from any person, any source whatsoever since the previous report?
Counsel, honestly, I think that the court can remember what Mr. Del Rionda said, and also there's a videotape of it. My characterization is irrelevant. I would say that he was emphatic, that he said that he had provided all that he had, and I hope at the end of the day that that's correct.
Mr. Del Rionda had questioned you about the perspective of the state attorney's office of looking forward after the first 4 years of being even better in how they approach their work. Is that correct?
That's, I think, what he read to me. I don't. If that was an Exhibit A, yes. Otherwise, he just read something that sounded like that. So.
Is there anything that led you down the path, be it the fact that you applied for a West Palm Beach state attorney and didn't get it, or that you're no longer with the Fourth Circuit State Attorney's Office, or that you only had 2 cases, that led you down a path that you would create or cause to be created false evidence or testimony about what the state did or didn't do in their discovery obligations?
No, Mr. Mayor, the only thing that led me here was an oath that I took in 1979 when I became a member of the Florida Bar.
Thank you. Nothing further.
Very briefly, Your Honor. You recall having a conversation with Scott Hughes?
I've had many conversations with Scott Hughes, the last of which was at the funeral of his wife.
Yes, sir. Specifically, you recall having a
I
conversation?
would object, Your Honor. It's outside the scope of
I don't
direct.
know that yet until I hear the question.
Yes, Your Honor. It's just that the man, Scott Hughes, was never mentioned before.
But the contents of the conversation may have, so let me.
You recall having a conversation with Scott Hughes the week of March 10th of 2013, where he was at lunch with his dad at Callahan Barbecue?
I do remember seeing them at Callahan Barbecue, yes, sir.
Your Honor, that it's outside the scope.
I consider that to be a preliminary question to have this witness understand any question about the conversation.
Specifically, you recall telling Mr. Hughes, pardon my language, Angela would have rather kept me in the house pissing out than pissing in?
I don't recall saying that, sir.
And do you recall telling Mr. Hughes, maybe we'll be working together in 4 years?
Same objection. I don't know when to make it now, but it is outside the scope of direct.
Your objection about the last question is overruled. Let me hear the.
The second question is, you recall telling Mr. Scott Hughes, who, by the way, is the chief investigator of the state attorney's office, correct?
Yes, sir.
Do you recall telling him that we will be working together in 4 years, meaning you will be in charge of the office in 4 years?
I don't recall that either.
Okay. You don't recall because you have a bad memory, or let's break it down. Did you have a meeting with Mr., did you see him
I
at
did
that
have a
barbecue?
meeting. We sat at the same table after I had had lunch at another table, and we talked.
You expressed your condolences regarding the loss of his wife, correct? Do you
Honestly, I
remember
don't remember if that was before or after the loss of his wife. I think it was after, but I'm not certain.
that? It was, but you expressed condolences regarding the loss of his wife.
Right.
Remember that? And you don't remember having a conversations where you used the words, I won't repeat them again, but regarding Angela, Miss Corey keeping you in versus keeping you out? You don't recall that at all?
No, sir, I do not.
And you don't recall stating to him that you would be working together, we, meaning you and Mr. Hughes, would be working together in 4 years?
I wouldn't have said that. I haven't made any decision about running against Angela Corey or running for that office or any office. So, no, I don't recall that.
Let's be honest here. Isn't this why this is all here? Because you want to draw attention to yourself regarding potentially running against Ms. Corey in 4 years?
That's, excuse me, that's absolute nonsense.
Okay. And finally, sir, did you turn over any evidence to Mr. O'Mara?
I have not turned over any evidence to Mr. O'Mara.
And as far as your knowledge, did Mr. Krybos turn over any evidence to Mr. O'Mara?
As far as I know, he has not turned over anything to Mr. O'Mara.
Do you have any idea how Mr. O'Mara would know and ask witnesses question in Miami when depositions were taken about a gun being mentioned in text?
I have no idea.
Thank you, sir.
I'm sorry, but thank you. The comment about whatever was just said, without repeating the vulgarity of it, was that a reference to an inquiry whether or not you were part of the source regarding information about upgrading retirement funds for Ms. Corey and Mr. Del Rionda?
I don't remember the conversation, so I can't speak to what it may or may not relate to.
Were you questioned by members of the state attorney's office regarding whether or not you had leaked information regarding putting more money in Miss Corey's retirement fund and Mr. Rionda's?
I was not.
Were you aware of that issue happening, and were you questioned at all about how it may have come about
Questioned by whom, sir?
by anyone in the state attorney's office?
No, sir.
Nothing further than your own.
Thank you. May Mr. White be excused?
Yes, Your Honor.
Mr. O'Mara, may Mr. White be excused?
Yes, thank you, Your Honor.
Thank you very much. You are excused,
Your
sir.
Honor, with the court's permission, I want to,
No. You're-
Your Honor, my client is entitled to an.
Wait, time out.
Okay, we had a call note saying, right now you've been excused. If you have an issue as an attorney's license presenting somebody, I'll hear you at that time.
Forgive me.
Okay, thank you.
I was going to just do what he tried to do from the witness stand, which is a relaxation of 9616 as far as the, hasn't been imposed yet, but the sequestration of witnesses to the extent that Mr. White is the attorney of record for the next witness.
If he wishes to remain in the courtroom during the testimony, he may do so.
Thank you.
Chosen to exit. Call your next witness.
Thank you very much. Have a look. Would this be a time, Your Honor, maybe for a,
We're off the record, but
Sorry.
she's changed. Do you want to take a brief recess? Okay, we'll take a,
yes,
Mr. De Rionda, do you have some of the evidence?
Mr. O'Mara got the evidence back.
Don't leave the courtroom with it, please.
I think you were the last one with
not
that
going to be the
evidence.
last time it happens.
And it was unintentional, I think.
Oh, this is my
I
copy.
think that's your copy.
Did I give you the right ones back?
Are we in recess?
What's your plan?
Scramble order is if she denies whatever for whatever reason is the condition. Then he emailed this morning. So we should probably address that with her first about the notaries and then secondly about just calling and getting it done.
When she comes back on the phone.